Good morning. I'm here as a practicing attorney at a fairly large research university, and Anne had emphasized the importance of this session being at least a little bit provocative and tackling issues of sort of current relevance. So I thought I would take us away from cases in the last portion of the talk this morning and actually talk about some hands-on issues with respect to online ed, MOOCs, and however some threads that I see emerging in that space in my own work for my institution and talking with colleagues at others around issues that really aren't about copyright, but I think are very important to librarians, issues like privacy and issues around data use and data rights. So here we go. I will spend about five to 10 minutes talking about some of the intrinsic copyright issues and concerns and IP ownership issues with respect to massively open online courses, and then you'll see we're going to move into some related spaces. So when we're talking about MOOCs or online materials, there are a number of sort of big overwhelming topics. One is, of course, course production and copyright issues, and I think some of you attended the a long session at this conference that Kevin Smith put on around copyright issues in MOOCs, which I'm sure was really wonderful. There are intellectual property and ownership rights as between faculty and institutions. And this is a topic that's heating up quite a bit right now. You've got the AAUP, the faculty organization, putting out a bit of a sort of call to arms around academic freedom rights and ownership of faculty and course materials, which they see threatened by the advent of university-sponsored agreements for massively open courses. We've got FERPA and ADA compliance, which I do want to talk a little bit about today. We've got EULAs and privacy policies inherent in participation in open online courses. And we've got some issues that I really want to close with today, which is just because it's free doesn't mean it's actually free. What's happening around data mining and data usage in this new space. And then finally, just the issue of compelled transfer of IP. And when I say compelled transfer, I mean compelled transfer of our faculty and students when they engage with cloud services around learning and teaching. It goes without saying that course materials are heterogeneous, and as someone who staffed my institution's project with Coursera, this really was brought home to me, because my thought was, well, we're going to have to get a release from the talking head up front who's getting filmed for that course, right? When you start to really think about what's involved in a course presentation, especially one that's going to succeed online, you're talking about a lot of other materials, all the fun little gimmicks. So, by the way, this talk today has been denuded of all the fun slides that I rip off the web like everyone else does to make people wake up and to say, hello, how about this point? Because unlike what Georgia did, I'm not making images the subject of this talk. Like many faculty, when I give a talk in a classroom or face-to-face that isn't being recorded, I use images to have fun. And faculty are used to doing those kinds of things in their teaching, and they're not used to thinking about rights concerns at all in that process. But those kinds of issues get very live and vivid. And then, of course, there's issues around delivery of materials to students or to participants in these open courses. All of these are different threads in the copyright equation. All of them really explode the safety of the traditional classroom and face-to-face teaching, which as librarians and others involved in the teaching and learning enterprise, you know we have a lot of liberty that comes from the copyright statute and a lot of liberty that comes from the realities of fair use in the classroom. But when you're interacting with a MOOC platform provider, they're going to treat you as an institution. If you're an institutional participant, you're having to take the role of warranting rights vis-a-vis a publisher. So we're now producing courses in an online environment where all of the conventional permissions and rights issues that publishers apply to our faculty when they publish books, or a film studio is going to apply when it's releasing a movie, really come into play in that same kind of way. And this is a sort of mental dynamic that I've found. Georgia and I were talking last night. Faculty who create these courses are not thinking about these issues. So the enterprise of trying to work with them and to have an institutional delivery of a MOOC course that is at least to some reasonable extent not totally illegal has been something that has really been challenging for us. Here's the traditional copyright exceptions that we love, that we use all the time in institutions of higher education. And they're built to support a pretty progressive and opportunity-rich teaching and learning enterprise. And the issue is that most of them, at least within the structure of the statute, are not written in terms of massively open online courses that are just generally available on the web. They're written in terms of specific hierarchies and structures within higher ed itself. And so what we're finding in this space is that fair use, again, is really, really important. And fair use has a place within the copyright advisory space for MOOCs. But what are the rules? And these are questions that I think really haven't quite been answered yet. So, for example, what are the rules when it comes to delivering these recorded course materials to thousands of individuals worldwide? Does it matter if the platform provider is explicitly for profit? We all know that we've seen the Supreme Court reject an analysis going back at least as far as Campbell versus Acuff Rose Music, the Two Live Crew Roy Orbison case that Georgia mentioned. The fact that there may be a profitable interest, motive, or result does not disallow fair use. That's a sort of old argument that was hurled at artists and others under the fair use test, and the Supreme Court said, that's not dispositive. I mean, it can be a factor, but it's not just because you're going to make money. If your use is truly transformative, you may still have a perfectly valid fair use case. But how does that concept apply in this particular environment? If you're posting courses on a platform provider who's not for-profit, and where, in fact, as I think we're all reading practically every day in the Chronicle of Higher Education or the New York Times, institutions are really looking for ways to obtain revenue from these programs long-term. So how does that affect the fair use analysis? Does our not-for-profit status help to outweigh the for-profit status of the platform provider? Does it matter, hey folks, does it matter if the content's being beamed to countries all around the world who don't have any fair use concept in their copyright regime? These are lots and lots of issues, and as one of my children said coming home from school one day, Mom, I'm perplexed by the 157 questions for which God has no answers. And, these are on that list too. He always was a smart kid. So third-party content, here's some pivots I'd say that I feel fairly strongly about, and I think, lots of my colleagues within the academy are centering our advising on, which is obviously third-party content that's integrated into, and it doesn't have to be a massively open online course, online courses, videos, content that's uploaded for broad public access. It's obviously going to work better if it's transformative, and Georgia has just demonstrated a number of very recent cases where courts are really agreeing with that. It's always important to remember the good, wonderful Ninth Circuit cases around the use of technology being our friend. So where it's possible to use content in a way that is not rivalrous with perfectly legitimate needs of content owners, that's a good way to go. If you can use thumbnails or low-resolution images, that's great. Links that are going to support a publisher's opportunity when you're using tiny bits of content can also be a helpful way to at least make content owners our friend and potentially also help with a fair use analysis. So I would say, though, that it's not viable, in my opinion at least, to say I'm going to upload a whole lot of book chapters so 100,000 students worldwide can read chapters of books. I think that's a licensing issue. People have got to tackle that one. IP ownership, just for a minute or two. This is an issue that I have found perplexing in its public parlance or discussion recently, because the reality is that this all boils down to the Copyright Act and institutional policy. And for those of you who are at educational institutions in the room, which I suspect are quite a few people, institutional policies around faculty ownership of intellectual property almost invariably distinguish between types of faculty output. I'd say all institutions at this point, except a few actually, say that faculty own scholarly articles and books. So faculty can produce scholarly articles and books that are the product of their research. They can do it at least in part on university time. They can sit in their office laboring over that. We want them to do that, right? It's part of the criteria of tenure and promotion, articles, books, et cetera. So, and we give the authorial rights to faculty, or we either restore them based on how our policy operates, or we never take them away in the first place. We explicitly carve that out. This is then where institutions tend to diverge a little bit. Some institutions, my own included, do assert an ownership right at the institutional level to course materials, just regular old course materials. It doesn't mean that we would say to Professor X who goes to Harvard or Berkeley because they get fed up with my institution, you can't take your syllabus and your lecture notes with you. But we would at least assert a right to hold on to that content at our own institution. And in fact, from a technical perspective, my policy says we own those goods. Other institutional IP policies tend to afford a broader swath of rights. So some institutions say faculty own all typical faculty outputs, whether it's course materials, books, or articles. But all institutions put a stopgap when it comes to the creation of intellectual property artifacts that employ significant university resources. Where you're getting a ton of support and investment from the university asserts an ownership right. And this comes in part out of patent law areas where faculty and where institutions need to have strong and clear rights to be able to disseminate IP in a patent licensing process and get royalties back, both for the inventors and for the institution. And since distance and online education courses almost invariably involve a ton of investment, one average I've heard is that the average massive open online course right now is costing institutions $100,000 to $200,000 per course to produce. When you're talking about video recording, addressing all the rights issues, support from grad students and others, that's a very significant institutional investment. And institutions, under their universal policies around this, really do own the IP rights, or at least have a claim to them which may be shared with the faculty. So the concept that participation in these projects is robbing faculty of rights is one that I remain puzzled by. But I think you're going to be hearing more about that, and I think some of where that's coming from is really a related interest, which is a perfectly understandable concern about displacement. So the issue around academic prerogatives to choose and create courses, the concern about displacement of teaching opportunities, those are realities. We're in a very disruptive space right now in higher education. And so those concerns are clearly being brought to bear around this issue. Regardless of how all this is settled out, as I said, platform providers want clear rights, because when an institution signs up and delivers a course to a platform provider for MOOCs, the platform provider wants to know that the rights are cleared and the rights are okay. Accessibility, a huge issue and a growing one, and one where the Department of Justice and the Office of Civil Rights are really slamming us, I think, probably for some good reasons, around accessibility of new technologies and new content opportunities. We all need to expect that any form of licensing, whether we're securing content from a publisher for journal access through libraries, or whether we are delivering content online, is going to be subject to ever more rigorous accessibility expectations under the ADA and under Section 504. So institutions that receive federal funds, which is, i.e., all of us, absolutely have to think about these issues. And we're being used, quite frankly, by advocacy groups to be the tail that wags the content producing and technology dogs. So under the ADA, the Department of Justice cannot tell, let's say, Google or Elsevier, thy content must be accessible. But they can tell institution X, Y, and Z that if we license content that isn't accessible, we're out of compliance. And so there's an explicit strategy to ensure that higher ed is fully aware of our obligation so that we push technology providers and content creators to render the content accessible and compliant. That's another sort of horizon issue I wanted to flag. It's coming up in the context of MOOCs, but it goes far beyond MOOCs. Okay, now let's downshift to a different gear. I'm really going to move away. We did a little bit here on ADA. Talk for a few minutes about privacy and data use issues, and then I'll get off and we can get into hopefully a great conversation. So what is it that's really happening first, let's say, in the MOOC space? Well, it's been pretty important to the for-profit Coursera to have in their terms of use one of those many long unread 17-page documents that we all click through and don't read, to say that, hey, you're not our student. I mean, we talk about students taking open online courses, but Coursera, for example, says you're not our student, and we're not subject to the Family Education Rights and Privacy Act, FERPA, which drives an awful lot of compliance efforts at institutions of higher education. So you're not our student, and because of that, institutions who are working with an entity like Coursera, and there's lots of other companies out there, are also wanting to be very, very careful, because we don't want to be in a position where it looks like we're enabling a formal student relationship with the institution that would give rise to rights and responsibilities, not only under FERPA, but around accreditation and all kinds of other compliance environments that would put the institution in a very, very bad place with respect to its delivery of content. So the paradigm is, we're giving you content, we're not enrolling students at the institution. So, but here's where things can get very interesting. So anyone here currently at an institution where you have created courses and uploaded them, where your faculty are flipping the courses? Okay, so me too. And one of the things that I realized kind of late in the game was that we had faculty who had created great courses, and they really wanted to flip the classroom and experiment with that model, which is a very, very interesting thing, one of the important drivers of this experiment with MOOCs. But they were having students just enroll with provider X in order to take the course at the institution. That brings FERPA right back into the picture. Because if the students in enrolling for that course have got to waive their FERPA rights and agree to have their data commercially used, then actually I forced a student at my institution to waive their privacy rights in order to take a course at my institution. And it's not just some participant non-student out there in the universe who's agreeing to that trade in exchange for free access to education. It's my institution. It's something to think about. You want to make sure that that's not actually happening and that students have a legitimate choice around privacy waivers. The issues around privacy and compliance are, by the way, going to be ever broader, because the EU has an even more rigorous structure around privacy than the United States does. And I think we can expect open online course providers to be grappling, as we see Google, for example, constantly getting sued in European countries around privacy practices. This stuff's going to be part of the online space as well. And this leads me to a final couple of slides, which is, and this isn't really just about MOOC providers. The EULA, the online license, the end user license that is getting thrown in front of us every time our browsers touch the web, is actually a really important thing for us to care about. And I think it's something pretty important for librarians to care about increasingly. And I know how ubiquitous this is, and I know how hard it is. Every single person in this room who signed up for internet access clicked right past a EULA. And you don't know what that said. You probably agreed to indemnify some company wherever the service is from. You probably agreed to be sued in whatever home state jurisdiction they have. You might have agreed to share data in ways that would not be very appropriate from the perspective of your institution's policies. You just don't know, because nobody reads them. And I'm here to say that when we're employing cloud products that involve a faculty or student's browser touching a web space, we actually should care about those issues. we should care about them a lot. Because fundamental issues, I think, of privacy, of IP ownership, and really of the use and access to data are implicated there. And when you start to read them, you find some very tricky and unpleasant things. For example, cloud products that are being tested by faculty in the classroom to measure learning analytics, which is one of those hot new terms. And you read through the license and realize that your faculty and your students have agreed that all of the IP that's created in that course testing space has been also given non-exclusively to the host and can be used by that company and reused by that company. And when the license does not comply with FERPA in the first place, and so your students in taking your class are having to agree to these kinds of terms, that's an issue of concern, at least to me. And I think it's the kind of issue that is also of concern to libraries. New copyright strategies of platform providers, whether they're MOOCs or others, also bring us back into this cycle, which is that platform providers are trying to do deals with publishers and content owners that are perfectly reasonable in their intentions. But if you're an institution and you've launched a course, and the course is being linked through content deals to publisher opportunities, you're not a party to that agreement. And if the platform provider is giving away the farm around privacy and IP ownership rights, and your faculty aren't reading this, and you're not interpreting it, and you're not realizing that by agreeing to utilize certain content or certain textbooks as part of a course, anyone who enrolls in the course is going to be dragged into a space, again, that has privacy or IP ownership and data rights implications. I think that isn't good stewardship. Cloud companies in general are seeing this space as really, really, opportunity rich. And frankly, they're counting on something that is true, which is that we can't all read these licenses. But when it comes to institutional programs, I mean, I have two grown-up kids now, and I know that they have very little of the sense of privacy that I might have as an old person. They throw their lives up on Facebook and they Twitter, and they really don't care very much about these issues. And that's fine in the private and personal space of all of us. But when it comes to the stewardship I think we have as institutions and libraries towards our students and faculty, I think we need to up the ante in our game a little bit. Here is, for example, something that just hit me in the last 2 weeks, which was in the middle of a negotiation I'm handling for many, many, many institutions in my state. It's a very, very big deal for a content license. And all of a sudden pops up, this is a deal we've historically done only every 5 years or so. So I'm going through the new license, and I realized that the hard-won compromise that library had for many, many years around usage statistics and sort of that balance of patron privacy and library needs and publisher legitimate needs had suddenly been tilted by a new little clause in the license that says, first of all, said that all privacy was going to be safeguarded except as described in the license itself, which was usage statistics based, or as described in the online privacy policy. And what's the online privacy policy say? Basically, we can change our policy whenever we feel like it, which is what we all know happens with online policies. And I strongly objected to this. I mean, this is not a situation where, frankly, we should have a EULA or an online license. We have faculty and students reading articles off this database. They're not uploading to the database. They're simply reading content that we are buying at enormous expense. And I don't think their privacy rights ought to be breached when we're paying millions of dollars a year to deliver content to them. You need to watch out for these things because if you don't, you're basically setting up a dynamic where the library license resources have become another tool to harvest data in ways that you may not think are appropriate. So I'm really happy that we already got an introduction to the wonderful Woody Allen, because I'm ending with Woody Allen here. Just because you're paranoid doesn't mean they're not out to get you. Now, lest you think that I've jumped off the deep end as a lawyer for my institution, all of these things are appropriately balanced. And we're living in a dynamic world of new technology. Data analytics are here to stay. And I'm not someone who's objecting to content owners having opportunities to interact with institutions around data sharing and analysis. That's going to happen. The issue is whether it's happening in a place where the fulcrum of sort of ethics and of stewardship is reasonable, and where we're paying attention enough to these issues to not frankly get dragged right off the boat into the deep end of the sea without knowing what's happening. So my admonition here is that we need to sort of be alert to this. We need to not check our skepticism at the door. We don't want to be so excited about winning these wonderful copyright battles in federal courts, which has been an increasing trend, that we lose our critical judgment around other things that could be happening, that could be undermining some of those victories at the very same moment. So thanks so much.